you?
I have to write down what you're saying.
All right, I know I've been a little fast in this trial.
I get it.
Rittenhouse, and the appearances are as before, outside the presence of the jury. And I have sent proposal, or draft number 3 of the to the attorneys this morning. And we'll make a record now on. Oh, would you get what's on my printer, please?
Hey, Judge, this was.
All right. Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections, requests?
We have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes. I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time, and when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And this is so typical of lawyers. We're hidebound. We've always done it this way. And I will tell you that for years I have. I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But, I'm not going to mess around with a case of this magnitude over 2 days or 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm going to have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without, there's already plenty of repeating going on. But if I have to do longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. You had, there's a
Well,
lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, well, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
Simply because of time.
Okay. I think I'll go back to bed. Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that.
Okay, forget it.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
Gross is the one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose, and we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just, that's on 2 also. And that's right after they've just heard it. So, all right.
Concern is that the instruction makes it clear that self-defense is an issue for first-degree attempt and second-degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Can you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're? Is that what you're talking?
That's on the, yeah, that's on, excuse me, I'm reading from the 4th count here. Let's see, let's have a look at what I said on 5. See, if I had set this up, I would have put a, well, I'm not going to say what I would have You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, I should say it, is all three elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that
the whole
self-defense
instruction
is an option.
Yeah, well, you're right. All right, I'm misunderstanding what your email says. So, if you are not satisfied beyond a reasonable doubt, well, there's more missing there than that. You know that? There's not the clause about if you are satisfied. All right, so it'll read at page 27, the fourth line will be, if you are satisfied that all three elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
Anything else on the instructions?
Defense?
So, Judge, this is more for the record, you've already made, I think, preliminarily, you had talked a little bit about the Ritchie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was, one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because he's the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It's
Element number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
On
His
what
conduct
point
in
do you
this-
want that put in?
I just think that makes it clearer. I mean,
Where do you
if-
want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
to Joseph Rosenbaum.
Joseph Rosenbaum,
His conduct did not create an unreasonable risk to Richard McGinnis.
yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, two of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What number, what page is that on?
I'm sorry, 34. And we are asking for the
Do
cautionary.
you want the word some instead of one?
Or multiple? Yeah, some is
Several?
fine,
How many was it? Two.
that I recall.
There actually were. Well, I don't think you asked Ms. Sword about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer? All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as it relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction. Say 245?
I think it's
No, that's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not face a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
There was no objection then, you see.
I understand. There's no basis for an objection, and they know that.
I don't know that. Maybe they do, I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer-reviewed. If they want to discuss the proprietary algorithms and how an analyst would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here and I troubled about it, and in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's a conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case, it's not mine. And I'm going to they have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge, are the court had modified a little bit count 6, which was the...
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramine was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these offensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 16 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right. And then count 6 is dismissed. What's next?
One other thing, Judge. I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. What I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know. I'm assuming,
I haven't even seen it.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will,
Okay.
if it's necessary. Okay. Came in this morning? Okay. Okay, anything else?
Were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just knew there were technical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded machine at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that. So if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it was pointed in that direction. I agree with that, but the statute's prohibition is pretty explicit, and I'm not sure that the evidence that you have, especially because it's just well, not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
Even if you see the firearm.
again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going all over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window, and so there's no real dispute that they are in that area, and that is where we argue that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
It's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start. Was it 941.20?
20.
Yeah. And that brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too. How would that justify? I mean, what does the jury do with that?
I don't fully understand the court's question. I would also note that he
is
did point
you?
the weapon at Mr. Rosenbaum.
Pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there would be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another? What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Could you start that over? I'm so
Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a
Well,
crime.
where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who is over there. That would be the only
I beg
evidence.
your pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say it. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury telling them, something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to. There's such a universe of possible statements that could be made that I don't want to try to, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind. But so I'm not going to say they can't mention that at all. That it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
All we have.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions, and call from the outside to, let's see. Nice weekend, and we'll begin our final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to each of counts 1 through 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for human life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct. When I was instructing you a moment ago on reckless homicide, I indicated there were two elements. There are actually three. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are three elements to that crime. And I also used the word both of the elements, and it's actually three. So I apologize for that mistake. And we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same three elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all three of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life, but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If you are not so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First-degree intentional homicide is defined in the Criminal Code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first-degree intentional homicide and must consider whether the defendant is guilty of second-degree intentional homicide as defined in the criminal code, which is a lesser-included offense of the first-degree intentional homicide. There are hierarchies of cases in the law. Typically, first-degree is the highest offense. Then lesser included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now the, but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser-included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person. A crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilty and a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify a finding of guilty for attempted first or second degree intentional homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The elements of each crime will now be defined for you in greater detail. Before you may find the defendant guilty of attempted first-degree intentional homicide, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being, and that his acts demonstrate unequivocally that the defendant intended to kill and would have killed the other except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide, and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the defendant is guilty of attempted second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor. The third element is that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved any one of the following. First, that the reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed that he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second-degree intentional homicide. First-degree recklessly endangering safety, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, I've got myself into a mid-sentence and I don't like it. the concern that I have, and I worked with the instructions all weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury, and decided I better talk to you people beforehand, is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example, and they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1, or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense? They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's what I used to construct these from scratch. And I would tell the jury, which I was just doing now, that once you have exhausted this, you're done. As opposed to having them needlessly go through these lessers if they've already concluded that, and this is a case where this could happen. I'm not saying it should or would. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of valid self-defense, then they really should not be considering lesser included. Am I right or wrong about that?
So if they find perfect self-defense on the charged count,
Yeah.
they should be told.
You see what this? Yeah, I'm sorry.
I mean, I understand where the court's coming from. I guess they could consider the other ones in 30 seconds and just go down to be not guilty. But
they're so complicated as it is.
no, I understand.
I feel terrible about giving this kind of stuff. It's just so. Well, anyway, see what the instruction is telling them, that kind of cryptically. It says it tells them if after a full discussion. It says, however, if after a full and complete consideration of the evidence you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them, yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward. Where
does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one can say that about all 30-some pages of the.
don't do that. People will find out our lawyer's secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see where he is, or what he's... I don't like the way I said that either. How about this? In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on...
So, for example, with
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
the jury,
Maybe the constructions committee is right. I don't know.
the jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's defined.
Well, yeah, you're right. He's right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over. Yeah. I think that's correct. Even your suggestion is seductive, Mr. Binger, but see, they're not asked to consider that. That's where I'm having the problem. You know, and they even make reference to it. I think maybe I read in one of the comments. They talk about we don't have, like some states do. They have a question right off the bat: was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury?
You should finish it.
And tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, you know, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide, and then we've given him the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court Reporter doesn't delineate between those two things, and I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well,
so again,
it is if you're talking just about an individual count.
But I was saying a blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing a count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's causing confusion. What the Madam Court reporter just read back, for example, could be construed as saying anytime with regard to any count you find justified self-defense, he walks on all 5 counts. And that is absolutely not true.
That's not what I intend to tell them at all.
I know you don't intend to tell that, but what's already been said gives that implication. And again, I just worry that the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them. And I am leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well, I could say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than most, than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found their defendant guilty, and I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense. And they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done. Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
But on page 10,
top page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first.
yeah, you're right.
Homicide.
You're right. It is in there as homicide. We didn't catch that last night when we talked about them. I sent you 3 drafts. But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy. Okay, thanks.
Are you anticipating closings before lunch now? It's after 11.
How long are you going to talk in your first sequence?
I'm going to try and limit myself to 2 hours.
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon, because the lunch has already been ordered. So, and I'm not going to comment on the lunch. So let's ask the jurors to come back in, please. So I'll take a break at. Why don't you around whenever you're comfortable around noon? Just ask for the break. Yeah, well, when he's the commander of the, I don't want to interrupt him at a time he doesn't want to be.
Did you get my eye up?
I did.